And I appreciate the good work you do. I do have some questions about all this. You were the person they sent to represent the DA's Association, so forgive my questions if they're, you know, a little detailed, but that's why you get the big bucks, right? So in any event, one of the things, all right, you understand, first of all, just to make sure we have some common ground, that when someone commits a predicate felony, my suggestion is that they would still be punished for the predicate felony. That we don't disagree on that, right? Someone commits a burglary, they'd still be punished for burglary, correct?
Yes, of course.
Also, do you disagree that we would still be punishing people, that under the current law, we are punishing people who did not intend to kill or even foresee subjectively that there would be a chance for someone to be killed? That is happening, correct?
Well, I was a defense attorney for many years, and I've heard the old story. It was an accident that I pulled the trigger. And quite frankly, honestly, they took a loaded gun to a robbery and they pulled the trigger.
See, this is where I'm very confused.
Well, and I mean, that's some of the things we hear now.
I'm not talking about someone who pulled the trigger.
Okay, you're talking about the accomplice.
I'm talking about eliminating the doctrine of felony murder, which means we take somebody who was involved in a predicate felony but did not have an intent to kill, did not act to kill. That's what I'm talking about, eliminating, in other words, punishing people for what they did. So you understand what we're trying to do, correct?
Well, I understand, and it's a matter of semantics very much. You need to look at the culpability of the individuals involved. And, quite frankly, when you say unintentional, if they caused a death, the issue of unintentional versus intentional, quite frankly, I think many times is the jury is making a decision. Now, if you're talking about, for example, on a robbery where we're dealing with a lookout, that might be a different...
Right. That's what we're dealing with specifically.
That's okay.
If I can ask a question. The question is, and the reason I'm asking these sort of foundation questions, and like, for example, you just said that, well, I've heard about accidental. I'm not talking about accidental. I'm not talking about where someone pulls a trigger. Let's focus on what we're actually trying to do, which is stop punishment for murder for people who did not murder anybody, okay? Now, you, in your written testimony, provided a number of examples, I think 6 examples, okay, of why it's important not to change the law. Almost all of these examples, 5 of the 6, have nothing to do with what we're talking about here today. I mean, for example, number 2, you talked about the murder of Richard Barber. You're familiar with that, or you have that in front of you?
The Barber, yeah, Barber.
All right. And it said a jury convicted, and I apologize for pronunciations if I get them wrong, Uradine Williams, a second-degree murder, for taking money out of an ATM in Philadelphia. He basically walked up to the victim, put a gun to his head, asked for money, and when the victim was hesitated, he shot the victim in the head. There was no other person there. This has nothing to do with what we're talking about today, okay? We're not talking about people who walk up and shoot someone in the head. We're talking about people who did not pull a trigger, did not know, for example, that that was even a possibility. Here's another one, case number 3, murder of SD. You talk about the conviction of Joseph Cornelius, who horribly molested and murdered an 11-year-old boy. But Mr. Cornelius did that by himself. There's no dispute that he was the one who killed this person. This has nothing to do with what we're talking about today. I can go through every one of these examples, and none of them have anything to do with what we're talking about today.
Well, and as I mentioned, I agree that I think after hearing the testimony, we're dealing, this panel is concerned about accomplices. And I understand your concerns, and I am telling you that, many times these awful, awful crimes cannot be solved but for the cooperation of the accomplices.
But let me interrupt you there. again, you can still charge if the accomplice is guilty, if you can prove it, of the predicate crime, the predicate felony, burglary, whatever it is. You can still make a plea deal with him on that, right? But you're not suggesting we charge people with crimes they didn't commit in order to coerce them to testify, are you?
Well, under the law, if you participate as an accomplice, you are guilty of second-degree murder.
And the reason, and because I can, unlike the 6 or so cases which have nothing to do with this, I could point, and there's already mentioned a couple of them, to a bunch of cases where the absurd, unjust result went the other way, right? And so, for example, the gentleman who testified here earlier, terrible with names, but I'll get this, Mr. Peters. I'm just going to read you a small part of his testimony. They had gone over to take some cash to buy back something, and the person that Mr. Peters was with, Lewis, I guess his brother, he came back and Lewis was arguing and striking the victim. The defendant, and again, let's assume this is true. I wasn't in the courtroom or at the scene of the crime, but let's assume this is true. I ran over to Lewis and said, "Lou, leave her alone. I have the money." But Lewis wouldn't listen to him, kept hitting her. And I slapped his arm down. I was begging him to stop. And then I'm pleading with him. He tried to prevent me from leaving. I continued pleading with him, showed him the money I had taken, hoping that it would make him stop. I realized he wasn't going to leave, so I ran to the back of the house, out in an alley, and I went to a bus stop and started crying. That's very different than someone who goes and shoots someone in the head, right?
Oh, absolutely.
And so, but what you said earlier in your testimony was we want the court to assess culpability. But under current law, they're not allowed to assess culpability. It's a mandatory life sentence, right?
That's correct.
So do you object to giving the court the opportunity to actually, as you suggested, assess culpability in individual cases?
Well, I would suggest that DAs be given discretion to withdraw the mandatory life sentence under the appropriate circumstance. The facts, as you have portrayed, I don't know what happened in Philadelphia. Quite frankly, I don't understand what they were doing. I can't answer for them.
So you and I agree on that.
Well, based on those facts, I can't.
Yeah, well,
I don't understand what happened in that case, and I don't understand at all.
So you think it's unjust to take someone, assuming the truth of these facts, to take someone who had no intent to murder, who in fact may have tried to stop the murder or at least been very distraught about it and did not participate in the actual murdering part. You think that's unjust to treat them the same as the guy in the one case that you talked about who strangled a boy to death and then cut out his intestines to make it look like, and cut his genitals off. You see those two defendants having different levels of culpability?
To say the least.
To say the least. You did say we should give the DA's discretion to withdraw the mandatory life sentence. What about, given that we have an adversarial process and that we don't give the defendants any unilateral opportunities to make decisions about charges, shouldn't it be the neutral fact finder? Shouldn't it be the judge who has the discretion to eliminate the life sentence in a particular case? Why should it be one side has all the power and the other side has none? Why shouldn't it be the defendant makes a motion based on facts to waive or eliminate the life sentence or whatever term we want to use, rather than the DA who has a stake in this as a party to the case in an adversarial system?
Well, first of all, we need leverage many times to get cooperation from those accomplices, as you refer to. Secondly, many times, if not all the time, the court really doesn't know all the facts. And you might seem bewildered about that, but quite frankly, it is rare that a judge will know all the facts regarding the investigation, regarding all the facts regarding the case. Typically, when we are dealing with all the facts of a intricate homicide, the court is not aware of many minute factors that could weigh heavily on their decision.
Mr. Adams, I don't disagree with that. However, would you agree that the defense attorney knows all the facts, probably, if they're a competent defense attorney?
Yes, I think that the
So
attorney...
shouldn't their role be equal to the DA's role? And the way that in our system is manifest is when the defense attorney makes an argument telling the judge the relevant facts, because not every minute fact bears on every issue, and then the DA tells the judge their version of the relevant fact, and the judge makes a decision. That's how we usually decide things. We don't just say, well, the DA knows best. You know, we would never do that in civil law. Well, the plaintiff's attorney knows best, so we're going to let them make all of the decisions in this case, right?
Well, we, as many times in our position, need leverage to be able to get and to bring the most culpable to justice. And that leverage, which we have in some of the cases that you've cited, are very important to us. And to give that up would probably prevent many of those most culpable felony murder cases go unpunished, and we would have those individuals again resurrecting violence in our communities.
Well, two things, and I'll wrap up this round after two things. But first, one additional issue. But on that, you keep coming. Your main argument, we've agreed on the injustice of some of these cases. Your main argument is we need to have this doctrine in order to coerce the witnesses to testify. And I just think, do you think that, people have served decades in prison because of an unjust doctrine to make it easier for a DA to prove a case. It just seems like a horrible injustice. Why not let the DAs decide to sentence everyone to mandatory life in every case? Shoplifting, putting your hand in a mailbox, spindling and mutilating mattress tags, because at least that way you can coerce them into testifying. Our job as policymakers is not to make your job effort-free. If you don't have the evidence, you shouldn't convict someone, but we shouldn't provide you with tools that result in horrible injustices to make your day easier. With all due respect, right?
Well, we need to protect those innocent victims who are killed as a result of some of the behaviors.
How about physical coercion? Would that be justified?
Excuse me?
Physical coercion.
Physical coercion? No.
Beating a witness or defendant until they agree to testify.
Absolutely. That's
Why?
not acceptable, nor
Not acceptable.
is that practiced anywhere in Pennsylvania.
Right, I agree with you. Even though in some cases that might result in you getting a conviction in a heinous crime that you would not otherwise have gotten. In other words, there are certain things we don't do just to increase the conviction rate, right?
That's correct.
And why should a man like Mr. Peters spend 36 years in prison? So you, for the sole sake of you having the opportunity to threaten someone else with that, and if they don't testify?
Well, I'm not familiar with Mr. Peters' case other than what I heard today, and I can tell you that the vast majority of district attorneys throughout the state have a lot of semblance of doing what is right. I'm not certain what took place 36 years ago in Philadelphia. I can't speak to that, but based upon the facts that you have told me, the outcome seems a little disproportionate.
Right. I'm assuming the facts here are true for the sake of this discussion, just like I assume the facts that you presented in the 6 cases you mentioned are true. Okay, so we're obviously not here to litigate those cases. But I'm always skeptical about public policy that relies on the goodness of people's hearts. Like, we're going to allow this very unjust law to stand because we know DAs are decent people and they're nice guys and nice women, and they're never going to use it in an unjust way. I am very, very troubled by that as a justification for a law. Finally,
Well, you know, what we have, though, and you bring up a point that let me reemphasize. Those cases should be brought to the attention of the Pardons Board, the ones that you have brought.
that
set
segues
forward.
to my next question.
Okay.
Which is, you mentioned, well, rather than changing the law and eliminate the possibility of this unjust thing, and there are, I forget the exact number, maybe my person has it or can find it, there are hundreds of people sitting in prison based on this doctrine around the country. Some states have recently eliminated the doctrine. Other countries have eliminated the doctrine. But a lot of people are sitting there, and often they're in jail longer than the guy who actually pulled the trigger. So, you know, like, worried about, like hoping the DA's, like, in a particular case is a nice guy seems an insufficient remedy. Then you point as another remedy to the commutation process. And I'll just make my 2 points, you can comment, and then I'll turn it back over to the chair. First of all, that's true in any case. I mean, that's an argument not against changing the felony murder doctrine. That's an argument against changing the law ever. Like, if there's an unjust law, we shouldn't change it. Just go to the Pardons Board. They'll take care of it. That seems like, again, an unsatisfactory remedy, especially given the fact that pardons, especially in murder cases, are almost impossible to get.
Well, I think that we
how
are
many
seeing
have
a
been
change
issued?
in
Do you
that.
know?
I think we're seeing a change. I know that historically, it's under other administrations, it was difficult. I think we're seeing a change in that, and
There could be a
I
new
think-
administration in Pennsylvania in 6 months that might
Yes,
have the
and
opposite view. Right?
I believe that whatever administration takes over, we're all very involved with criminal justice reform, and this is a fact that the Pardons Board, I think, is opening up their processes to take a look at many more of these cases. Hopefully, they will do so.
I would say in almost all of the cases I've seen before the Pardons Board, the DAs actually oppose the commutations.
Well, I have a letter here that was written by Fran Chardo, who is with us, who actually has agreed to the pardon in a second-degree murder case and has sent a letter to the Board of Pardons asking.
That's great. Do you know how many have been issued? How many pardons or commutations in second-degree murder cases in, let's say, the last 20 years in Pennsylvania?
I do not have those.
All right. Thank you, Mr. Chairman.